let's get to Andrea. We're really excited to have her. She is a local attorney in the area. She specializes in estate planning, trust, and probate law. Andrea is an experienced and certified from the California State Bar as a specialist, and again, in estate planning, trust, and probate law. She is also a graduate of magna cum laude at the California Western School of Law in 2006 and opened her own practice, Shoup Legal, in 2012 here locally in Temecula, Murrieta area. Is it Temecula, Andrea?
Yes, yep.
Yes,
Temecula Murrieta area. Yeah.
Okay. And Andrea also enjoys getting to know each of her clients, their concerns, and their wishes in order to tailor a plan that best suits their needs. She takes pride in providing excellent and individualized attention to each client, helping them understand every step of the process. Andrea lives in Murrieta, California, with her husband and their 4 children. And I hear that you're getting a puppy.
Yes, we are. Yes, on Monday.
Oh, you're excited?
Super excited. So we're getting a German Shepherd and we get to pick her up on Monday. We're so excited.
Oh, that's so much fun. The kids are going to love it too, I'm sure.
Yep. Yep.
Well, we're excited to learn from you. I've heard wonderful things about you and just everything that your knowledge. So I'm really excited for us to learn from you today. So take it away.
Well, thank you. I really appreciate the opportunity to talk with everybody today. And yes, I am. We are in Murrieta, Temecula area, but actually I am coming live today from Ocean Beach. I'm down in San Diego because we are here on spring break with my family. And so we are down here in San Diego. So we're actually from San Diego originally. So love it down here. So let me get my PowerPoint shared. Did that work?
Yes, looks great.
Okay, very good. So I'm going to talk to you today about the ins and outs of probate real estate and what you really need to know about selling property after someone's passed away. And kind of what does it mean? What does it mean? What does probate mean? What is all that stuff? I'm going to talk to you about that today. And I just want to make sure that everybody can hear me. So can you hear me now? If you could just type in a Y or a yes in the chat, just to let me know that I am coming through and that you can see my screen and hear me, that would be awesome. Okay, perfect. Thank you, guys. All right, so what you're going to discover today, we're going to talk about what happens when a property owner dies. We're going to talk about the probate process, how to list property in probate, as well as how to avoid probate. Okay, so those are the topics that we're talking about today. So the first one, what do we do when a property owner dies? So when someone's on title, right, we've got to make sure that the person who is on the vesting deed can sign the deed to transfer it. Well, if they've passed away, that can't happen, right? They can't obviously sign a deed once they pass. So what do? That's when we're looking at how property is held. And that's really important that you guys know as listing agents and as buyer's agents, well, who owns this property? How is property held? So one way, and of course, because I'm an estate planning attorney, I love to see it held in a trust because that's basically the easiest. So when the property is held in a trust, right, and the property owner has passed away, that trustee actually becomes fairly simple when they've passed away, because what we do is we prepare, have notarized, and record the affidavit change of trustee. Then whoever that successor trustee in the trust was, they step in. That is the new person who's going to be signing all the documents on the, the listing agreement, the transfer to sign the house, the transfer deed, everything. That's the person who will be able to do it. So when the property is held in a trust, it's super easy. If they passed away, we complete this affidavit change of trustee, we record it, and now that successor trustee steps in. That is what it allows to have happen and makes it pretty simple when it's held in trust. So here's the catch. If there was no successor trustee listed, or that successor trustee has already passed, or they've all passed, then we've got to petition the court. I'm going to talk about that in a few minutes, how we do that if that's what happens. So what happens when property is held in joint tenancy? Well, joint tenancy is pretty special because it has an automatic right of survivorship. What does that mean? It means, let's just say we have two people on title, right? We have Bob and we have Jane. If Bob passes away and he's held it as joint tenants with Jane, Jane automatically is the 100% owner. It's instantaneous on the moment of Bob's passing. It automatically is now held 100% by Jane. And all we have to do is complete, notarize, and record an affidavit, death of joint tenant. That tells the world, tells everybody, Bob has passed away, and now everything is owned by Jane. She is the 100% owner. So if Bob passes away in that situation, it becomes pretty simple. Now we filed this affidavit, death of joint tenant, and Jane owns it 100%. All right, what happens if it's tenants in common, right? Well, what does that mean? Basically, it's a default. Every deed, if it doesn't say something else, it says tenants in common, even though the words aren't there. And it's a default, and this does not have a automatic right of survivorship within it. Meaning, like the one before, joint tenancy, Bob passed away, automatically goes to Jane. That does not happen with a tenants in common, because there is no automatic survivorship or succession built into it. So unfortunately, when, let's say it was Bob and Jane again, and it didn't have those magic words of joint tenants, or it says tenants in common, when Bob passes away, we have to go to the probate court so that it can either transfer to Jane if that's appropriate, or basically it transfers to Bob's successor, whoever that may be. And I'll talk about how we figure that out in a second. But when it's tenants in common, so we have two people, we have Bob and we have Jane, and it's tenants in common. If Bob passes away, we've got to go to probate court. Why? Because Bob isn't there to sign the transfer deed, right? The only way we can have a transfer when Bob's passed away is with a court order. That's the only way. I know you're going to tell me, well, what about if I have power of attorney? Does not work. Powers of attorney, it extinguishes upon passing. Well, what if Bob left a will? Great. Probate court will handle it. Okay, so there's no automatic succession, nothing easy that we can file. We've got to go to probate court. What about when property is held in someone's individual name? It was just Bob on the deed. There was nobody else. There was no tenants in common, no joint tenancy, no spouse. Well, what happens then? It's the same thing. Unfortunately, we've got to go to probate court because we have no one to sign the deed. The only way we could transfer property when someone has passed away, if they didn't have a trust, this is in their individual name, is with a court order. And we've got a ton of our escrow friends on the line. Help me out. You have this going through the escrow process. Bob's passed away. He's the only person on title. Can you accept a power of attorney? Anybody?
No.
How about the son? He's the only son. Come on, you can just let him do it, right?
No.
What are we looking for? We need to have that probate court order. We've got to have it. That escrow is not going to close. The title's not going to let it go through. You've got to have a court order. So when does that happen? When do we have to go to probate court? And what's the difference between probate court and a full probate? I'm going to talk about all that. So probate happens when we have any real property. So let's just say we're going to keep using Bob. Bob's passed away. If Bob owned any real property, I don't care if it's, a condo on the beach, or a piece of land in the Salton Sea, any real property, we're going to probate court. All right, we need a probate order. Or if Bob owned assets, that means all his assets, your car, your personal property, your bank account, anything, and that totaled over $166,250. Okay, if either of those are true for Bob, we have to go to probate. We need a probate court order. That's when a probate will occur. That's when probate court will happen. So what's the difference between a probate order and a full probate? A probate order, so probate court, it's an umbrella term. There's a lot of stuff that goes on in probate court. That's kind of like criminal court, right? Well, there's a lot of different things that happen in criminal court. It could be a DUI, it could be a shoplifting, it could be a homicide, a murder. There's a lot of different things that happen in criminal court. That's the same in probate court. So there's a full probate, and I'm going to talk about what that full probate looks like. Or we just need to go into court, get a quick probate court order, and then come back out. And when I say quick, that's my definition of quick. I will tell you, I guarantee you, my definition of quick is different than your definition of quick. My definition of quick, whenever I need a probate court order, if I can get into probate court and get out in about 60 to 75 days, that is lightning fast. That is super fast and quick, because I live in the world of full probate, which usually takes about 2 years to complete. So if we just need a probate order, sometimes we can get in, get out, and we're good, and rather than needing that full probate process. So what are probate orders? When can we just get in and get out with a quick order? Remember, my definition of quick. All right, sometimes this is available when we have a spousal property petition. Well, what's that? That's when, let's go back to Bob. Bob has passed away and he was married to Jane. Great, but Jane wasn't on the deed to the property, right? It was just vested in Bob's name. Well, if he was married to Jane, Jane can go into probate court with this spousal property petition and come back out in about 60 to 75 days, give or take, and have a court order that says that Jane is the new owner of that property and whatever property she's entitled to. Now, there's some intricacies, you know, was it community property or separate property? And that's all stuff that the probate attorney can help navigate through and explain. But the idea is, if Bob had a surviving spouse, if any person who passes away was married to someone, they can do a spousal property petition. An affidavit regarding real property of small value. That is another way we can go into probate court and come back. This one, thankfully, we can get this done sometimes in about 30 days. The reason it takes 30 days is we need to have the property appraised by a probate referee. A probate referee is a court-appointed appraiser. Yes, we must use the court-appointed appraiser. No, it doesn't matter how much experience we have appraising, evaluating property, we've got to use the probate appraiser. But if they deem the property to be under $50,000, that's what it was before, now it's $66,000. If the property value is under that threshold, and the probate referee says that, so that's when, you know, that lot in the Salton Sea, if that's part of it, but that's what we're trying to sell, we can actually, with that appraisal done, we can go into court and get a signed order within just a few days. It's actually fairly instantaneous. Once it's all complete, it just takes a while to get all the moving parts of it. It used to be when the courts were open, we could walk in, the clerk signed it, and we walk back out same day. Unfortunately, the courts just don't process documents that way. Thank you, COVID. But once that opens up, it'll be even sooner. The biggest delay, if you will, is with getting that appraisal from the probate referee. The next time we need a probate order, not a full probate, but a probate order, is a petition to determine succession to real property. That's available to us when the property is valued at $166,250 or under, and that's valued again by that probate referee, that court-appointed appraiser. If the value of the property is under that threshold, then we can do a petition to determine succession to real property. That takes about that 60 to 75 days. It depends. The courts are moving a little bit quicker than they had been. With COVID, everything just kind of powered down. And once it powered back up, it took a while for it to kind of get caught up with itself and deal with the backlog. It's getting pretty good right now. Usually I can get a court date in about 60 to 75 days when I file something. So it is quite quicker than it had been before. So this is available when that property is valued at 166, 250 or below. When I say valued, I'm talking about the gross value regardless of mortgage. So let's say the property is worth, you know, $300,000, but it has a $200,000 mortgage. Well, the equity is only 100,000. That's below that threshold. No, it is not. It is the fair market value. We take that $300,000. That's the value we use. So the fair market value, what it can be listed for, is sold for, that's the value we're looking for to see if this works. All right. Also a Hegstead petition. What is that? Some people have heard it. They've heard this term. They're not really sure who the heck Hegstead is. What is it? So this is what it is. Sometimes people they've done great. They've gotten themselves a trust. They tried to do their estate planning and have it all done. But the house was outside of the trust, meaning that when you pull the vesting title and see who's on that vesting deed, who owns it, it did not say the trust's name. But there is a trust. When we have enough, we can go in and say, hey, court, don't make us do that full probate. Look at the person meant to have this house in this trust. Please give us that court order that says that that house really is trust property. That is an Hegstead petition. And we're able to do that many times when somebody did have a trust, but the house didn't get transferred. Or what actually happens very frequently is the property did get transferred into the trust. However, they refinanced it, right? The lender took it out of the trust and nobody put it back into the trust. That happens all the time. Well, if that happened, that's another time we could do a Hegstead petition. Another one is if there was a trust, but we didn't have a successor trustee. Well, we need to have a successor trustee listed. So if the property, yes, was in the trust name, but that successor trustee after Bob, who passed away, let's say it was Fred, and Fred's passed away too, well, then we need a court order saying who the successor trustee of the trust is. The judge has to order that, and that's when we might need a probate court order as well. So I will tell you, when a full probate is needed, that full process, there is no avoiding it. There is no workaround. There is no, we might do that, we might not. There's no avoiding it, okay? When a full probate is needed, you cannot avoid it. It must happen. So let's talk about that full probate process, okay? So not just going in and coming out with a certain order, but the full probate process. Basically, what we do, the first thing we do is we file an initial petition for probate. That is when we say, hey, court, knock, 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 here we are. We need to open up a probate. We are usually able to get a date in about 45 to 60 days. Sometimes it's been about 75 days now to get our initial hearing. After the initial hearing, assuming that the court grants our petition, letters are granted. I'm going to talk about what that means, letters, but basically that is the court authorization for the probate. That is the authorization so that the administrator, the person who is in charge of the probate, can start acting on behalf of the estate, including selling the property. So it takes about 2 weeks or so, give or take, for the court to process the letters and get those letters back to us. After letters are granted, within 4 months, we must file what's called an inventory and appraisal. That is when we inventory all of the assets of the estate. So the real property, the personal property, the bank accounts, bank account numbers, balances, everything. If they had stocks, we have to get those appraised, everything. And we're going back to that court-appointed appraiser because that's who we've got to use. And we have to file that within 4 months of letters being issued. Within a year or two after letters are granted, we must file our final accounting and the petition for final distribution. That must happen. You can sometimes get extensions on that if there's a good reason, if there's a reason for a delay, and unfortunately there many times are, but then that can extend longer. But assuming there is no delay, nobody's fighting, nobody's contesting everything, usually about 1 to 2 years, we're able to file for that petition for final distribution. Once that hearing occurs, another 45 or 60 days later, then the court will grant the order. About 10 days after that, that's when the estate can finally be distributed. So it takes a good 2 years from beginning till the end when everything can be distributed. And I'll tell you that is a difficult process for a family who's already suffering the loss of a family member, but that is a different topic. So the timeline that you're concerned about as agents is, when can we list the property? It's about 60 to 75 days from filing the initial petition. Once those letters are granted, then you can list the property. All right. And I'm often asked, but Andrea, can't I just list it before? We know that this person's going to serve. Please don't do it. Well, Andrea, look at the hearings coming up next week. Can I just list it now? Please don't do it. I understand. It is, you want to. There is, you want to market it. It's a great property. We don't want to lose the listing. There's plenty of reasons. It is in everyone's best interest, especially yours, not to list it before you have the authority and before the court has granted the petition in favor of the person you think is going to act. One, crazy things happen in court, very unexpected things sometimes. But number two, nobody wants a stale listing. To list property and have it sold through the probate process, it's going to add time anyways. The last thing you want is to extend it out or be kind of like that problem listing or problem property if the hearing did not go as planned. Best practice, please listen. Just wait until those letters are granted before listing the property, before marketing it, making it live on the MLS. It is so much better all around that way. And then there's no impediments. Now you're not waiting for that court hearing to make sure you have the authority to sell and list that property. All right. So some common probate terms that come up: executor, personal representative, administrator. What do they mean? For all intents and purposes, they mean the same thing, okay? The administrator, that is the person who has the ability to act on behalf of the estate. When you're listing the property, you want to make sure the person signing your listing agreement is the personal representative, okay? You've got to make sure that they're the ones who have the authority with the court to be able to list the property. Probate referee, we talked about that. That's the court-appointed appraiser. That is the one who must value the property. That is your court-appointed appraiser. Yes, we've got to use a probate referee when it's required. What is an heir? Basically, it's the person who naturally would inherit from the person who's passed away. So in Bob's situation, let's say Bob wasn't married and he had 2 sons. Well, his heirs are his 2 sons. That's who would naturally receive his property if he passed away and he hasn't done his estate plan. Well, then what's the difference between an heir and a beneficiary? Well, let's just say with Bob, he had his 2 sons, but he loved the spotted owls. He wanted to save all the spotted owls. And so he left in his will the beneficiary of, Save the Spotted Owls Today, organization, that nonprofit. So the Spotted Owls organization would be his beneficiary. That's who he has listed for himself to receive all of his assets. That's his beneficiary. That's the difference between an heir and a beneficiary. Heir is your natural heir, who the probate code says is your successor to inherit from you. Beneficiary is who you choose for yourself. Sometimes they're the same. Let's say Bob didn't care about the spotted owls and he loved his 2 sons and wanted to give everything to them, and he named them in his will. Well, then they would be the beneficiaries. So letters testamentary, letters of administration. What does that mean? What's the difference? Again, for all intents and purposes, letters, it's the same. Yes, there's a difference. I'm not going to get into the distinctions, but this is the court authority. This is the ability, the hall pass, if you will. This is what gives that personal representative their authority to act on behalf of the estate. And this is what you've got to make sure you have and that you've read so that you know who can list it. Because When you get close to closing the escrow, guess what the escrow officer is going to ask and the title company is going to ask? They're going to make sure that you have certified letters of administration or letters testamentary. They need that so that they know that the person signing that transfer deed actually has court authority. So let's talk about the probate listing addendum and advisory. So this, I will tell you, this is a copy of letters. This is what it looks like, and this is where you can get some information from. First, it says it right there, letters, and it'll be checked if it's letters testamentary, letters of administration, and so forth. For the probate advisory and addendum, you're going to need to get the information from the letters. This is where it comes from. You can get the case name. Here it's Mary Smith, aka Mary Jane Smith. I will tell you, when you pulled that vesting deed, because I know everybody's pulling the preliminary title report. They're making sure they know who sells or is selling the property. They're talking to the right person, right? Well, when you see that, make sure whoever's on that vesting deed, if it says Mary J. Smith versus Mary Jane Smith on the vesting deed, but you don't see that iteration here, Mary J. Smith, on the where it says estate of, bring it to someone's attention. It has to be exact. You would think, well, if the vesting deed says Mary J. Smith, that's pretty close to Mary Jane Smith. It's many times it's not close enough. We need to make sure that the AKA has that on there. All right, where do you find the case number? It's right there. It will say case number and you can pull it from there. Who has authority? The court will appoint somebody. So here the court appointed Sally Miller, and you pull that right here from it. You have to read it. The court appoints Sally Miller. Make sure you're talking to Sally Miller. Make sure it's Sally Miller who's signing your listing agreement. All right. You're also going to need to know what kind of authority the person has. Do they have full authority or limited authority? That is one of the boxes to check on the probate addendum as well. This is where you find it from the letters. You pull it right there and it'll say whether the person has full authority or limited authority, because this tells you whether court confirmation is required for the sale of the real property. We'll talk about what that means in just a moment. All right, so full authority. It means that no court confirmation is required to sell the property. So a lot of times when we hear about a probate sale, we hear about, oh my gosh, something needs to be published, there's an auction, I don't get it, I don't know. Yes, that is when court confirmation is required. When it's not required, then it's very much like a normal listing. When you have full authority and no court confirmation is either required or being sought. There are certain times where somebody might have full authority, but they're still asking for court confirmation. But if it's not, we're not going to have to get the sale of the property confirmed by the court by a separate hearing, then it's very similar to a normal listing. It's not identical, but it's very similar. There's a few different forms and disclosures that are and are not required, such as a probate addendum and advisory. That is required, but it's very similar to normal listing. You've got to use, and I have here probate listing agreement. You use the normal agreement, but you use the probate addendum and advisory. So I apologize for that. You've got to use the probate addendum and advisory in relation to the normal normal listing agreement. Yes, a probate referee appraisal is still needed. We've got to get it valued by the probate referee. When you have limited authority, or basically no authority, you have authority, but as far as selling the property, you have essentially no authority. A court confirmation is required for the sale of the property. This is where it is in that other realm. Yes, it has to be published. Yes, you have to seek court approval. And yes, sometimes there is an auction. So it is very different from a normal listing process. One of the first things to do, I would say, if you have a probate property at all, if you're in a situation where the property owner has passed away, please get in contact with the probate attorney quickly. Establish that relationship and the communication. So you guys both are on the same page and you understand each other and you know what's needed and what's coming up. And ask them, hey, are we going to have to get court confirmation on this or not? That will let you know what you need to do and what that listing agreement looks like, or the listing process looks like. You've got to use the normal probate, or I'm sorry, the normal listing agreement with that probate advisory and addendum. And yes, the appraisal by the probate referee is required. The California Association of Realtors, they have certain exemptions and requirements when listing property. Some of them, to me, are quite interesting. What is required and not required when selling property in probate. So some of the requirements, I'm sorry, the disclosures that are not required are here listed on your screen. I always am amazed that the operable smoke detector is not required. I don't get it. Best practice, please make sure it's still there. You know, safety first. Let's make sure everybody's safe and make sure that there is an operable smoke detector, but for whatever reason, it's not required. Other reasons why, like the seller's property questionnaire, why is that not required? Well, a lot of times, let's say it's Sally is the administrator for Bob's estate. Sally many times didn't live in the house. Maybe she's only walked through it once, but she didn't know all the things that have happened with the house, so she can't fairly answer a lot of those questions. Some of the disclosure requirements that the seller must still comply with. So interestingly, this still requires the carbon monoxide detector. Again, I've never understood why no smoke detector, but why carbon monoxide detector? I don't get it. Do them both, regardless of it, whether it's required or not. Again, safety first, make sure everybody's safe. All right, so what does that court confirmation process look like? Let's talk about that. So this is when we're petitioning the court and telling the court, hey, we're selling the property and please bless it for us. So first, the notice of sale must be published in a newspaper. Now, thankfully, this is something that the probate attorney should be handling, but it is something that they're going to need to do and handle. So it will be published in the newspaper. It will require a hearing to confirm the sale within 30 days of the sale. So once the offer has been accepted and all of that, you have to get that information over to the probate attorney very quickly so that they can file the petition to confirm the sale and that the hearing will occur. Some of the requirements are that, let's see, notice has been properly given and that it's been published, as well as certain terms in the purchase agreement must be clearly stated. With the overbidding, there will be overbids. So this is that idea of an auction. So this is where it gets kind of interesting. Now, let's say you have marketed the property and it's been great. Yay, we have a buyer. And the buyer's like, cool, I just scored a great deal. Well, in court, if we're doing the court confirmation process, another buyer can come in, overbid that sale, and walk away with the property. All right. So you've got to make sure that you're aware of that. One, if you're the seller, but also definitely when you're the buyer. If you're on the buyer side of it, you've got to attend that hearing. You've got to make sure that you protect your buyer and make sure you're aware if there is going to be an overbid or not and what that looks like. Definitely be in contact with the listing agent and see if they're aware of any overbids. Many times the listing agent will be aware because they'll be contacted regarding it. So in Riverside County, overbids must be in writing and filed with the court. And there's special rules regarding the broker's relationship to the buyer, as well as the recipient, so the buyer's relationship, who that they could be to the administrator. So we want to make sure that everybody's getting a fair deal, that it's not some secret inside deal, and that they're getting too good of a deal. So on the petition for the order confirming the sale of the real property, there's information that you will need to provide, including a description of the property being sold. Is it 100% of the property, or are we selling only 50% of it? Is it improved, or is it unimproved land, and so forth. Also, we're going to need to have the information for the appraisal, how much it appraised for, because when we're petitioning the court for confirmation, the sales price must be within 90% of the appraised value. Meaning, let's say the property appraised for $1 million, the sales price has to be at least $900,000. So it has to be within 90% of the appraised value of the sale. Also, the manner of the sale, the terms, and so forth need to be listed on the petition. What's here, we have to give the court the information to calculate an overbid. So let's say that the bid amount is $550,000, right? The way we calculate the overbid is we take the first $10,000, and it's 10% of that. So that's $1,000, right? Then we take 5% of the original overbid, the original bid minus $10,000. So in this example, if the original bid was $550,000, then 5% of the original $550,000 minus $10,000 ends up being $27,000. You add that together, the original bid, 10% of the first $10,000, 5% of the original bid minus $10,000, you add that up to $578,000, meaning the first bid must be at least $578,000, so that we don't have somebody being like, okay, I'll bid $5 more, right? We don't want to just go up incrementally. So the first overbid has to be enough of an overbid so that it is worthwhile, if you will. And then from there, the court will set its own bidding. A lot of times they'll go either by $5,000 or $10,000 if there are people in court, and it literally becomes an auction, and the judge becomes an auctioneer of sorts. Like, okay, now we have $578. Anybody overbid? Okay, you have $578. Anybody want it for, I don't know, $590? And so him or her will go through and actually auction it. All right, so you must make sure the listing agreement is for no longer than 90 days. You've got to accept the highest and best offer. So it's a combination, it's highest and best, it's not just highest. So sometimes when that person comes in with a cash price that ends up maybe a little bit less than the credit price, it ends up being the highest and best combined, all things combined. You've got to open up the listing to the open market. Best practice listed on the MLS, and whereas, as I mentioned, the probate referee appraisal value has to, the sales price has to be at least 90% of that appraised value. So in case you were wondering, yes, you need a certified copy of the court order, as well as a certified copy of the letters of administration. The escrow officers will be asking for this. They need it to close escrow. A few challenges with listing property in probate is you have little access to funds for repairs and costs. Also, improvements might not be reimbursed by the court, so you've got to be careful. Talk with the probate attorney regarding any improvements that you are considering, so that we make sure that it is something that will ultimately be reimbursed by the court. The personal representative must adhere to court standards for decisions. So they have to, when they're accepting the highest and best offer, they've got to make sure that they're using what the court allows them to use to evaluate that decision. Many times you don't have help for clean out, junk removal, and so forth. And really, you're working with a grieving family. So you have to make sure you keep that in mind. Many times somebody just lost their mom, their dad, a brother, sister, sometimes a child. It's a difficult process for them, so be aware of that. So you've got to be flexible. Expect the unexpected. It always comes up. You've got to work closely with the probate attorney, develop that relationship early, and keep that communication going. And nothing is final until it's final in regards to the sale of the property, okay? Work with the probate attorney, it's important. Some resources for your seller. One, take the listing if you can. Your seller is talking to you because they trust you and they want to work with you, so take the listing if you can. Some of the greatest resources that you can offer really is yourself. Again, work with or develop a relationship with a good probate attorney to help you with it. So if you're talking to Sally, who's like, oh my goodness, my dad just passed away, what do I do? You can say, you know what, I can help you list the house. You need this great probate attorney to help us through the probate process. And then you're sure to know, okay, you understand the process and you have a great relationship with the probate attorney. So you guys are working on the same page. Because at the end of the day, you guys want the same thing. You want to sell this house as quickly and efficiently as possible. You've got to work with an amazing title company, amazing escrow company, because that is hugely important. You've got to have an estate sale company available to you, because a lot of times it's needed. A moving company, make sure that you have somebody that can help if they need to move their items out. A cleaning company, a trash removal company, and then a contractor for repairs. Also, after closing, you've got to encourage proper estate planning for people so they can avoid that whole process I just spent the last 40 minutes talking about. You've got to help them avoid that. To avoid probate, it's really important to make sure that they have a revocable living trust set up, because a properly drafted trust, a properly funded trust, making sure the house is in the trust can completely avoid the probate process. Some people ask, well, what's the point of a revocable living trust? One, it can avoid the probate process either through probate or a conservatorship. A conservatorship is what is a court process when somebody's incapacitated. So they haven't passed away, but they're incapacitated, and the court needs to appoint somebody to act on their behalf. I will tell you, I've spent nearly 15 years in court, practicing in court. Nothing good happens in court. You've got to avoid it. You've got to help your clients avoid it. It saves tens of thousands of dollars. I didn't talk about the cost of probate, but on average, most probates cost about $25,000 to $45,000 just for the sheer honor and privilege of going through that probate process. It is very expensive. It also would save 2+ years in court, avoids family fights, avoids uncertainty, and people choosing for themselves who is in charge. I will tell you, all California homeowners need to have an estate plan in place so that their family doesn't kind of suffer through going through court and a lot of the hassles and uncertainty. If you want to learn more about estate planning, I'm almost out of time. I promise I'm just wrapping up, but please go to our website, shouplegal.com, to upcoming events. We always have estate planning workshops and other events coming up. But really what is even better is join our advisor network. What it is a network of professionals and advisors that we work with so that we can get you information so you can be the first to know changes and updates in the law. With the Prop 19 update, once that happened, those in our advisor network, we were able to get them information quickly, tell them about the change, and provide resources and solutions to their clients very quickly, and really did a lot of transferring and a lot of stuff before that law went into effect. So if you want to be kind of the first to know updates in the law and get great resources out to your clients and be that trusted resource for your clients, join our network so we can update you on changes. We also provide resources for building your business, as well as VIP access to our network. We have several events throughout the year that we would invite you to. Also, you can receive exclusive trainings. We do realtor specific trainings as well that you would have access to, as well as access to trainings for your clients. That's something that we provide. Basically, if you want information about how to avoid probate and on estate planning to your clients, we do specifically branded to you, to your company, and to you personally, that type of training for your clients. To join our advisor network, just email info@shouplegal.com, subject line advisor network to be added. You email, we will get you added. You'll get and no, we don't spam you. Nothing like that. It's you'll get a welcome email, and then we have great information and resources that come out. One thing I did want to offer you is, if anybody has, I think there's questions. I haven't been monitoring the chat just because it tends to distract me a little bit when I'm talking, but I'm going to turn to the chat in just a few minutes so I can answer whatever questions you have. But if you would like specific individualized training on probate and help for yourself, I invite you to set up one of these strategy sessions. At the end of our time together, you're going to have personalized training to discuss these concerns with your clients. a plan to protect your family as well as to protect your business. And this is how it works. Basically, it's a 45-minute meeting, either at our office or a Zoom call. You know, that's one of the great things about the last year is that we have gotten so much more used to Zoom and Zoom meetings. So it's a meeting with a member of our legal team. And during that meeting, we're going to train you to discuss probate avoidance tips with your clients, discuss your concerns and your goals for your family and your business, develop a strategy to protect your family and build your business, as well as answer whatever questions you have about your unique situation. So all of this is generally valued at $750, but to honor our time today, if you want to book one of these trainings and strategy sessions, it is only $249. Now, their way you schedule is to chat message me, Andrea Shoup, your name, phone number, and email address. If you send that to me, a member of my team will reach out to you to get you scheduled. So if you basically you're telling me today, yes, I'm interested. Okay, what's the catch? There is no catch. I just have only 15 spots available just because we have limited time and limited availability in our calendar. I see 52 people on this call. So if you're interested, I suggest message me now. It's just because I have limited, limited resources in my office and want to provide this to you. And thank you to Heritage for making sure that this was available to you at this discounted cost. So to receive the discounted cost, you've got to let me know today. Just send that information to me, and you just have to send it directly to me, to Andrea Shoup, your phone number and your email address so that we can contact you. So with that, if you have any questions, please let me know. I'm going to turn to the chat now, see what questions we have. Let's see.
Andrea, Patty
Yes.
did ask, I was keeping an eye on the chat, and she wanted to know if you've ever had a probate sale that didn't require working smoke detectors, since it's California state law.
I've never actually closed one that did or didn't. I'm very curious why it is something that isn't required from the California Board of Realtors. But again, best practice, always do it. There's no reason not to do it. It's just one of those quirky things that I don't understand why it's like that. But I think it's always been an interesting, quirky thing to me.
And I do want to address that you do work with all of San Diego, including Temecula, because that was brought up.
Yeah, absolutely. We help clients actually throughout the state, depending on the situation. Definitely with probates, we have probates in probably 10 different counties right now throughout the state. We have one in Marin County, San Francisco County, many different counties. So yes, we do work throughout the state as for estate planning as well, depending on what the client's needs are. I have clients up in Sacramento right now. I'll probably never meet them in person, and they're completely fine with that. Again, because of the last year, they actually feel better about doing Zoom calls rather than coming in to an office. So yes, we work throughout the state.
Okay. There was a question about the slides for this. Will you be able to provide the slides for this to be sent out to everybody?
Sure. My assistant Trent can help us get the slides over to Heritage, and then you can send them out. Also, if you'd like, you can if you send me your email address with that request, my assistant can help us with that as well.
Perfect.
And
Thank
yes,
you so much.
You can message me either through email, so the email's here. You can message me through there, or you can message me on this chat as well. I would just, find my name. It's Andrea Shoup, so that it would only be seen by me rather than all the panelists and attendees.
Perfect.
Yep.
And then there was a question about the recording, and this is being recorded. And as soon as it's available, we can send that out to you. Just reach out to your local sales rep and they'll get that to you. So fantastic. And then Were there any other questions for Andrea before we jump off? Everybody
Okay.
is,
So I'm just have to say something.
yes.
Whoever said attorneys were a bore? You are so much fun. You are blessed. Let's go have cocktails.
Yes.
No, honestly, this was great. I was just, I honestly absorbed everything. It wasn't a bore at all, and so appreciative of your time, Andrea. Thank you.
Absolutely. Well, thank you for allowing me to chat with you this morning. I'm happy to answer any questions, but I really appreciate the opportunity. I mean, it really shows how much Heritage Escrow really cares about those that they serve, that they're providing information to everybody and making this available. So, Tamara, I appreciate you asking me to participate, and I'm just honored to be here. So thank you very much.
Thank you so much. That's our goal, just to bring the value and educate. So thank you so much. Appreciate you.
Of course, of course.
Thank you so much, Andrea. I think that's all of the questions for today. And then you did put, it was info at Shoup for any questions if they have any outside of this meeting.
Yes, exactly. Info at Shoup Legal, SHOUP legal, LEGAL.com. So info at shouplegal.com.
Perfect. Thank
Great.
you so much. We really appreciate it.
Of course. Thank you. We'll talk to you guys
Thank
later.
you.
Have a
Have
great
fun out
day.
there. Thank